So in Florida, child support is calculated based on a statutory calculation. There are a few different things that come into play, one being the parties' respective incomes, the amount of overnights that each of you have with your child or children, and then a few other things depending on your situation. Some of those things being who covers the health insurance for the minor children. Are there any daycare expenses? Is this a military situation where either party may have BAH or BAS, taxable income versus non-taxable income, who's going to claim the children on taxes. All of those things come into play. So essentially, we plug it into a calculator, it comes out with a number, and in Florida, there's not a whole lot of battling when it comes to child support because the number is what the number is. There's not really anything that you can do if you feel like you deserve more or if you feel like you should be paying less. The court's really going to go with that calculation, and legally, the court can only deviate 5%. But in most cases, whatever the number is what the number is going to be. Child support can be modified in Florida based on a substantial change in circumstances. So most commonly, people seek modification if maybe one child is aged out and their original parenting plan did not account for a step-down provision where that child has aged out and now there's another minor child left or other minor children. You will essentially file a supplemental petition for modification, saying that there's been a substantial change. Maybe that substantial change is that you've had a change in your income. Maybe you lost your job and now you can't obtain a job making what you were making before. Maybe now you're disabled. There's several different things that can lead to a modification in child support. In Florida, whenever someone has not been able to make a child support payment, technically they are in contempt of court. So that means that the other party has the ability to file a motion for contempt asking the court to enforce that court order, basically establish an arrearage amount and seek sanctions against that party. So in Florida with child support, if you're in a situation where you're not sure if the other party is going to actually pay whatever they're supposed to pay, what we typically recommend would be for you to seek an income withholding order or an income deduction order. Those terms are the same thing. So essentially what that does is that is a court order that goes to the payor's employer saying, hey, take out this amount of child support and it will automatically be paid to the state. You'll create an account with the state and then you'll be able to receive your child support that way. If you have any questions about child support, how it's calculated, or how to enforce a current child support order, feel free to contact us at Cooper & Cooper, PA.